Dear friends, welcome back to my channel. I'm Advocate Dipshikha Gogoi, and today I will talk about a very important as well as a very sensitive matter, that is about daughters' right in father's property. There are equal rights and liabilities of daughters. Daughters have equal rights as sons in her father's property. The Hindu Succession Amendment Act 2005 was enacted to remove gender discriminating provisions in the Hindu Succession Act of 1956. Under the amendment, the daughter of a co-parishioner shall by birth become a co-parishioner in her own right in the same manner as the sons. This amendment came into force on 9 September 2005. The Hindu Succession Amendment Act 2005 has a retrospective effect. Section 6 of this act says, when a male Hindu dies intestate, having at the time of an interest in the Mitaksara co-parishionary property, his interest in the property shall devolve by survivorship upon the surviving members of the co-parishionary. Now let's know what are the legal rights of daughters in her father's property. According to the Supreme Court judgment, in her father's ancestral property, a daughter gets an equal right along with her brothers. The Supreme Court on January 21, 2022 made it clear that Hindu daughters would be entitled to inherit the property of their father in the absence of any other legal heir. They would receive preference over other members of the family in inheriting the property even if the father does not leave behind a will. That a daughter can inherit property of father if there is no will. In a significant verdict, the Supreme Court in this year, it was said that the daughters of a male Hindu dying intestate would be entitled to inherit the self-acquired and other properties obtained in the partition by the father and preference over other collateral members of the family. The judgment, which came on an appeal against the Madras High Court verdict, dealt with the property right of Hindu women and widow under the Hindu Succession Act. It is clearly states that if property of a male Hindu dying intestate without a will is a self-acquired property or a family property. It is clearly states that if property of a male Hindu dying intestate without a will is a self-acquired property or a family property, the same would be devolved by inheritance and not by survivorship, and the daughter of such a male Hindu would be entitled to inherit such property. Do daughters have right to inherit father's self-acquired property? Yes, earlier, before passing of the Hindu Succession Act 1956 and Amendment Act in 2005, division of property in India among Hindus are quite different. Provisions previously sons had complete rights in father's property, whereas daughters has limited rights over father's property or father's estate. Once a daughter was married, she ceased to have any rights over father's property, and property passed on sons and sons or sons so on. As per the amendment of the Hindu Succession Act in 2005, have got daughters an equal rights as sons and equal shares, liabilities, rights as that of a son. This is a legal journey of a woman from inequality to equality in living of a predominantly patriarchal society. Now, giving daughters a right to succession is a very new and recent concept. Usually, the property of the father is recognized to be the sole rights of the sons in many parts of the country. According to the Hindu Succession Act 1956, a son had complete right over father's property, but the daughters enjoyed these rights until they got married. But the Hindu Succession Act 1956 was amended in 2005 with the idea of leveling these differences. After the amendment of this act, daughters has a status of co-personers by birth, and she will continue to have property rights in her father's property throughout her life, irrespective of her marital status. There are two types of property under Hindu law: ancestral property and self-acquired property. Now, the rights of these two types of property also different. Ancestral property is a property which is inherited up to 3 generations. This property descends from father, grandfather, and great grandfather, whereas self-acquired property is a property bought by the father by his own money and by his income. In the ancestral property, the daughters has a birthright. That means a father cannot sell, dispose, transfer such property to any third person by excluding his daughters, by excluding his rightful legal heirs, that a father cannot deprive his daughters her share in the ancestral property. In case a father bequeaths such ancestral property in favor of some third party, then a daughter will reserve a right to raise an objection. On the other hand, talking about father's self-acquired property, which a father bought from his income or own money, a daughter does not have right of this father's self-acquired property. It means a father can give such self-acquired property to same third person, and a daughter will not have right to raise an objection. However, if a father have died intestate without executing a will, without transferring such self-acquired property in the favor of some third person, the daughter will have an equal right to claim equal share as sons to the self-acquired property of the father. Devolution of property when father dies is done according to section 8 of the Hindu Succession Act. When a father dies intestate without executing a will, his property will devolve amongst the class 1 legal heirs, which includes sons, daughters, mother, widow, and so on. Thus, a daughter has an absolute right in the property of a father when he dies intestate. When a mother dies intestate, the devolution of property goes into her sons, daughters, children of predeceased sons and daughters, and husbands has complete right over her property. In August 2020, the Supreme Court of India has passed a landmark judgment known as Vinita Sharma versus Rakesh Sharma, which it has held that sons and daughters will have equal rights irrespective of the fact the father is alive or not. The Supreme Court also said daughters remains loving daughters throughout life. Thus, she shall remain a co-personer throughout her life. The court also explained that the amendment of Act of 2005 applies retrospectively and not only in the cases when the father is alive as when this amendment act was enforced. However, this is subject to the condition that property should not have been partitioned on or before the date 20th December 2004, that is the date when the Amendment Act was introduced in the Parliament of India. Only daughters have benefited from this judgment of 2020. It means daughters, irrespective of their marital status, will now continue to have rights over their father's property. In simple words, a daughter of married, unmarried, or a spinster will continue to have rights over her father's property. The judgment of 2020 has not only enhanced the confidence of women, but it also uplifted their social worth and equality. Dear friend, if you like today's content, please don't forget to like, comment, or subscribe my channel. I will be back very soon with a new topic. Till then, bye bye.